Imagine pouring confidential company secrets, sensitive customer data, or even your personal thoughts into a chatbot, only to discover your private conversations might be stored indefinitely. Right now, a fierce legal showdown between the New York Times and OpenAI could change the way data privacy works for millions relying on generative AI tools. What does this mean for the future of AI, user trust, and your own digital privacy? To understand what's at stake, let's step back. In late spring of 2024, Judge Ona T. Wang ordered OpenAI to preserve all ChatGPT output log data as part of an ongoing copyright infringement lawsuit brought by the New York Times against both OpenAI and Microsoft. This order supersedes OpenAI's promises to delete user conversations, raising urgent questions for everyone from corporate clients to casual users. It's not just about one tech company versus one media giant. This is about how the legal system, business, and technology are colliding in real time with global implications. For years, AI companies like OpenAI have reassured users that their chat data can be deleted or is only stored temporarily. This has been a key way for organizations to manage risk, safeguard proprietary information, and comply with privacy laws. But with Judge Wang's order, those guarantees have been put on hold. Now, OpenAI must retain all conversations, even if users or contracts demanded deletion. The worry? Sensitive customer lists, trade secrets, or any confidential information entered into ChatGPT could stick around much longer than anyone planned. This comes as privacy laws are rapidly tightening. The California Consumer Privacy Act, the Virginia Consumer Data Protection Act, and similar laws in Colorado and Utah all give consumers the right to access, delete, and even opt out of the sale of their personal data. Over in Europe, the AI Act has introduced even stricter controls, especially for high-risk applications like healthcare or recruitment, requiring transparency and strong risk management. As Daniel J. Solove, an expert on privacy and AI, puts it, AI highlights deep-rooted flaws in current privacy laws, bringing these issues to the forefront. And yet, this new court order seems to freeze those consumer rights, at least for now. So what are the real risks? Organizations that use ChatGPT may now struggle to honor promises to clients or comply with local and international data privacy rules. Picture a financial firm under contract to erase client data every 30 days, suddenly unable to do so because of a U.S. court order. Or a startup worried that its intellectual property, typed into ChatGPT, is now a sitting duck for cybercriminals in the event of a data breach. As the Cloud Security Alliance warns, governance is about crafting a shared vision for innovation, ethics, and accountability. But when the law and technology clash, that vision gets blurry. The stakes are enormous. Experts estimate the AI market could top $3 trillion by the year 2034. With so much value, innovation, and sensitive data at play, the way we resolve these conflicts will shape not just business, but society itself. The legal system is grappling with whether copyright protection should override privacy rights and whether preserving evidence is worth putting user data at risk. So, as OpenAI and the New York Times battle it out in court, users are caught in the crossfire. Can companies trust AI tools if deletion can be suspended at any time? Are current privacy laws enough to protect us in the age of generative AI, or do we need entirely new frameworks? The next moves from the courts could set the rules for decades. And with new regulations and standards on the way, the future of privacy and AI has never been more uncertain. But what happens if OpenAI can't find a way to balance user privacy with legal demands? And could this case set a precedent that forces every AI company everywhere to rethink how they handle your most sensitive data? But what does this court order really mean for the future of artificial intelligence and global privacy? Let's look ahead to the possible scenarios that could unfold and how these decisions might ripple across the entire tech ecosystem. Legal experts warn that if OpenAI is forced to retain every single ChatGPT output, the stakes for privacy and security rise dramatically. Imagine millions of conversations, some filled with trade secrets, confidential client data, even sensitive health and financial information, locked away instead of being routinely deleted. As Daniel Solove puts it, AI is exposing the cracks in our privacy laws, and unless we act, those cracks will widen. If regulators in Europe, the United States, and beyond see this as the new normal, we could be heading into an era where AI companies must always choose: comply with court orders and risk breaching privacy laws, or delete data and risk losing critical evidence in ongoing lawsuits. It's a legal tightrope with billions of dollars and reputations hanging in the balance. On the flip side, this case might push the industry to innovate faster. Privacy-enhancing technologies, like federated learning and differential privacy, could become standard requirements, not just best practices. But these too have trade-offs. For example, differential privacy may weaken the usefulness of data, making it more difficult to improve AI models. What about businesses and regular users? Companies relying on ChatGPT will now face tough questions. Is it safe to input confidential or sensitive data? Should they pause their use of generative AI until new safeguards are in place? And what will this mean for future contracts with AI providers, when even ironclad promises about data deletion can be overruled by a judge? There's also a growing risk of data breaches. Massive stores of retained AI chat logs are tempting targets for hackers. Industry alliances like the Cloud Security Alliance stress, governance is not just about compliance, it's about building a shared vision for innovation, ethics, and accountability. So what can you do, whether you're a business leader, a developer, or just a curious user? First, get informed about your rights and obligations. Privacy laws like the California Consumer Privacy Act, the Virginia Consumer Data Protection Act, and the European Union's AI Act now give people more power over their personal data than ever before. For instance, under these laws, you can demand to know what data is being collected, request its deletion, and even opt out of certain uses altogether. If your organization uses ChatGPT, review your contracts and update your internal policies. Consider restricting the type of information shared with AI tools until there's more clarity. Communicate openly with clients and partners about how data is being handled and any changes that might affect their privacy. On a personal level, think twice before sharing anything sensitive through generative AI. Until the legal dust settles, it's wise to treat all chats as potentially permanent records. But here's the big takeaway. This legal showdown is forcing the entire industry to confront a fundamental tension. Can we have powerful, transformative AI and still protect individual privacy and intellectual property? The answer, for now, is complicated. The court order doesn't offer a perfect solution, but it does shine a spotlight on the urgent need for better rules, stronger technology, and ethical leadership. The secret fact? The global AI market is projected to surpass $3 trillion by the year 2034, but none of that value will matter if trust is lost. As Ashita Jain from Informatica puts it, privacy innovation and AI are twin engines. They must work together or risk stalling out. So, will this case reshape how sensitive data is handled across the AI industry? Absolutely. The precedent set here could spark new regulations, change how companies build and deploy AI, and redefine what it means to trust technology in our daily lives. If you want to stay ahead of these fast-moving changes, hit that subscribe button and turn on notifications. What topics about AI, law, or privacy do you want us to explore next? Drop your thoughts in the comments below.